Okay, welcome back. In part two of this week's video, let's talk about some specific cases and specific inmate rights that are going to be in some of the cases you're going to read this week. Let's start with a case called Turner versus Safely, and set in 1987, because this case is probably one of the most important ones in the whole book, because it establishes the conditions under which a prison or a prison system may violate the rights of an inmate. This case started as inmates in Missouri sued challenging a prison rule that placed restrictions on mail correspondence between inmates and mandated that the warden had to give permission for any marriages that occurred within the prison. The Supreme Court said in this case that prison regulations that infringe upon an inmate's constitutional rights are valid, that prisons could violate an inmate's constitutional rights as long as it was related to a legitimate peniological interest, as long as it supported the needs of the prison in securing order. And what do you figure that? Well, you decide whether or not there's a valid, rational connection between the regulation and a legitimate government interest that's put forward to justify it. You must decide whether or not there are alternative means of exercising the right. So if I pass, let's say if I'm a warden, I pass a regulation, the inmates and it violates the constitutional right of the inmates, it's okay if there's a connection between the rule that I passed, and maintaining security and order in the prison, and securing safety of the inmates. I do have to look as a warden. I do have to make sure make sure that there aren't any alternatives before I pass that regulation. Maybe there's some way that I can meet the same goals without violating the inmate's constitutional rights. If there is an available alternative, then my regulation is unconstitutional. And then I've got to look at the impact of accommodating the asserted right, and look at that impact on operating costs of my prison, on the resources that I have available. Even if there is an available alternative for respecting the inmates or protecting the inmates' rights, if it's beyond the resources of my prison, I can restrict it. Other important cases you'll see about this week, now let's talk about access to courts. Probably my favorite one is Ex parte Hull in 1941. And I love it because in that particular prison, poor Hull, the inmate, tried to file a writ of habeas corpus. He was convicted of a sex offense in Michigan. He attempted to send this right out by mail several times. Well, mail is checked, coming in and out of a prison. And so the guy who checks the mail opens it, sees what it is, and gives it to the warden, and the warden won't let it go out. And the warden says, we'll deal with this in-house, and won't let this guy file his writ of habeas corpus. Well, Hull tries several times to send his writ of habeas corpus or send letters to the U.S. Supreme Court, and the warden won't let him go out. Hull eventually got his writ out during visitation. He smuggled it to his father, who eventually got the writ filed for him. That's why it's called Ex parte Hull, because ex parte is Latin and basically means that you're doing something on the behalf of someone else. And Hull's father had to do that on his son's behalf because the inmate himself couldn't get the letter out. The court in the case, once the petition finally got to them, ruled that prison officials may not, under any circumstances, infringe an inmate's right to file a writ of habeas corpus. Now, we've already talked about some restrictions the Congress has put on that now, and that have been upheld by the Supreme Court. But all those restrictions don't say you can't do it. They just say you have to do it within a certain time limit, and you have to exhaust your other remedies first. In 1969, another landmark case, Johnson versus Avery, affirmed the Hull decision, and further brought about this decline of the hands-off approach in corrections, and it addressed the First Amendment protection of free speech and association. The issue at hand was the right of whether or not inmates could provide legal service to one another, the so-called jailhouse lawyers. Everyone's heard that term, jailhouse lawyer. Lawyers that help inmates that help other inmates with legal matters. In this case, Johnson, a Tennessee inmate, had been cited for helping another inmate prepare a writ of habeas corpus. An action was directly in violation of prison policy. When this case finally got to the Supreme Court, the court held the policy was invalid, and that inmates were able to help each other with legal matters or provide legal assistance if there was no other legal assistance available. Like the Hull decision 28 years before, Johnson versus Avery establishes that access to the courts for prisoners cannot be denied or obstructed. Uh, it even said inmates in ADSEG are, that access can't be obstructed. Um, what the court is basically saying, though, is yes, prisons, you can tell jailhouse, deny or put laws against having jailhouse lawyers, against inmates helping each other. But if you do, you have to provide some other sort of form of legal assistance, whether it's a law library or paralegals or some other source of legal advice has to be available if you're going to say that inmates can't help each other. In 2001, we did see in Shaw versus Murphy, 2001, the court says that inmates do not have a First Amendment right to provide legal assistance for everyone else. And so, yes, legal jailhouse lawyers are legal. Yes, you can restrict them, but if you do restrict them as a warden, you have to provide something else. The courts have further said, and when you read about Bounds versus Smith, you'll read the prison authorities are required to assist inmates by providing meaningful access to courts, by providing inmates with access to law libraries or adequate assistance from persons trained in the law. However, in 1996, several years later, the court said in Lewis versus Casey that this is only violated if the prison officials do something to hinder the inmates' access to courts. As long they just have to have a law library. If the law library itself is inadequate, because the prison just doesn't have the budget to have a good law library, that's not a denial of access to court. Now, if the warden refuses to provide the law library or the legal assistance, then we're denying the access. But if the prison is doing what it can, if the prison provides a law library, if the prison allows for law students to come in and advise the inmates, if the prison allows for paralegals, inmates can't say, well, I don't want paralegals, that's not good enough, I want a lawyer, you're denying my access to the rights of the court. The court's going to say, no, you're not. Brief list about First Amendment issues with this time. Probably a big important case, Thornbury versus Abbott in 1989. It says that prisons can reject publications only if those publications are detrimental to the security, good order, or discipline of the institution. And then there's a nice list of things that the prisons can restrict publications, magazines, books, newspapers, that sort of thing. You can restrict those if they describe procedures for creating weapons or does in some way facilitates escapes. You can't subscribe to Prison Escape Monthly. That'd be a neat magazine to publish, wouldn't it? If it provides how to make your very own liquor still, prisons can say you can't have that. If it's written in some sort of code, if it depicts activities that might encourage violence in the prison, you can restrict those. If they're sexually explicit in such a way that they pose a threat to the good order of the prison, and so pornography, it is legal and it's constitutional to restrict inmates' access to pornography. Other First Amendment issues, Procona versus Martinez says that censorship of the mail is constitutional, but only to the extent to which it's necessary to maintain security, order, and rehabilitation of the prison. The way this normally works is that all mail, outgoing and incoming, is searched. Usually, the prison officials won't read every letter that goes out. What will usually happen is inmates, when they turn their letters in and mail them out, they don't seal them. There'll be one or two people, prison guards, that's their job, is to monitor the mail, and they'll open the envelope, and they'll scan over the envelope, they'll look for gang symbols, they'll look for keywords, things like that, and let it go. Incoming mail is opened, it's not exactly read, but it's scanned for keywords, for indicators that there's something that might disrupt prison security in the mail, and then it's passed on. Of course, it's also search for contraband. Mail cannot be censored just because someone talks bad about the prison. If you're the guy you're the guy reviewing the mail, and you open the mail, and the inmate's trying to write out, and he's just complaining left and right, and he calls the warden everything in the book but the warden's name. You can't censor the mail for that. I mean, the inmates have the right to complain. In general, mail that is not privileged may be opened by prison authorities, checked for contraband, read or reviewed for plans to perform illegal acts, and then reclosed and delivered to the inmates. Other First Amendment issues, of course, you can probably guess inmates have the right to practice their religion, even uncommon ones, and so prisons have to provide reasonable accommodations for just about any kind of kooky religion out there, as long as the requirements of that religion are not illegal. Give you, for instance, when I was a correctional officer, Administrator Texas Youth Commission in Mart, we had some Rastafarian offenders, and part of their religion is the dreadlocks. It's part of their religion. We had to let the kids keep their dreadlocks. Of course, we put a condition on it that they had to keep them clean, because if they didn't keep their dreadlocks clean, that became a sanitary issue, and then we had a reasonable justification to shave the kid's head. When it comes to religious rights, inmates must be given reasonable opportunity to exercise their religious beliefs. See Cruz versus Beto in your textbook. Inmates may file suit if they allege that they've been punished for requesting religious materials. See Cooper versus Pate. Prison rules. Other things about First Amendment. Prison rules require books and magazines to come from publishers as constitutional. Most prisons I know do that. If you want to send a book to your friend is in prison, you can't just mail in the book. You have the book mailed directly from the publisher. So you buy the guy the book on Amazon.com, and rather than mailing it to him yourself, you just have it go straight from Amazon to the prison. And then when it comes, freedom of press. We'll talk about freedom of press real quick. In California, there was a prison regulation that prohibited media interviews of specific inmates. That has been upheld, doesn't violate the First Amendment. The Supreme Court has said that the press is not entitled to any more access to the prison than any member of the public has. And so if the press doesn't have the right to go places in a prison, that any visitor might be able to go. And I think that'll do it for this week. Now, I haven't covered everything in the textbook. I've just kind of hit some of the highlights, talked about it a little bit. So make sure you read the cases in the textbook. Make sure you pick your one that interests you. I said Ex parte Hall is probably my favorite from the inmate rights section. And then maybe Turner versus Safely. If you're looking for one that there are lots of journal articles about, law journal articles to write about, Ex parte Hall and Turner versus Safely are probably your best bets. There's tons of stuff out there on those. It'd make for probably, for your first two papers, be an easy one to work on. All right, well, that's it for this week. I'll see you next week.